Good afternoon. I don't even know what date it is, but it's a little past 4:30. We hope you have supper ready, and we plan to not be here all night, so I'm glad you're here. Madam Clerk, will you take the roll, please?
Representatives Campbell, Carringer, Davis, Doggett, Farmer, Fritz, Glenn, Hardaway, Howell, Lamberth, Moody, Russell, Sherrill, Towns, Vice Chairman Gillespie, Chairman Halsey.
Here.
Mr. Chairman, you have a quorum.
Thank you very much. Any personal orders? All right. We will get started then. The very first item, House Bill 1029, has been rolled for 1 week. That puts us at item number 2, which is House Bill 1030 by Chairman Doggett. You're recognized.
Motion.
You have a motion and a second.
Thank you, Mr. Chairman. I do have an amendment.
Is that this one?
Drafting code is 7132.
Okay, before we get to that new amendment, I need a motion to reconsider our actions on an old amendment. Motion and a second? Second. All right, all those in favor say aye. Aye. That amendment is now removed, and now we're going to reconsider a new amendment, 7132.
Yes, sir.
I need a motion and a second. Got a motion and a second? All right, you want to explain the amendment? You want to put it on?
If we can put it on, please, that would be greatly appreciated.
All right, all those in favor of 7132?
Aye.
Aye. All opposed, no? There are no noes. All right, the amendment's on to be recognized.
Thank you very much, Mr. Chairman. This legislation makes changes to the current repeat violent offender law, which is vital for holding repeat violent offenders accountable for their actions while also protecting victims and the public. This legislation states that for repeat violent offenders, if they receive 3 strikes for committing violent offenses, they will be sentenced to life in prison without the possibility of parole. The court will deduct a half strike from the defendant's total number of strikes for only half and quarter strike offenses. For each 3-year period, the defendant has no criminal convictions. That's new with this amendment. Also, the defendant must receive at least 2 strikes from the offenses that are listed in the 1-strike category, and a combination of the defendant's prior convictions equal 3 or more strikes. Now, this is not retroactive, so this would only include offenses that occur on or after July 1 of 2023. Now, there's some 49 offenses that result in 1 strike, 15 offenses that result in a half strike, and any other felony offense results in an offender receiving a quarter strike. And with that, I stand ready for any questions.
Okay, you've heard the explanation of the bill. Any questions for the sponsor? Representative Hardaway.
Thank you, Mr. Chairman. Sponsor, give us just a sample of some of the 1 strikes.
Yes, sir. I'd be glad to. We can female genital mutilation, domestic assault as defined in 3913-111 when the offense is a felony offense, grave torture if the defendant was a juvenile at the time of the offense but was convicted in criminal court and sentenced as an adult, second-degree murder, vehicular homicide, aggravated vehicular homicide, especially aggravated kidnapping, trafficking for a commercial sex act, advertising commercial sexual abuse of a minor, aggravated human trafficking, aggravated robbery, especially aggravated robbery, carjacking, aggravated rape, aggravated sexual battery, aggravated statutory rape. Would you like for me to continue, or?
No, sir. I was looking for a couple of offenses, and you did call them, at carjacking in particular. Thank you.
Yes, sir. Thank you.
Any other question for the sponsor? All right, with no objection, we're ready to call the question. We are voting on House Bill 1030. All those in favor say aye.
Aye.
All opposed, no. Ayes have it, goes on to finance.
Thank you.
That brings us to item 3. Is that correct?
That's correct.
SJR 0035 by Chairman Reagan. Motion? Second? Sir, you are recognized.
Thank you, Mr. Chair and committee. Members, I bring you a proactive bill, actually, resolution. The purpose is to reject and disapprove of the American Law Institute's 2022 changes to Article 213 of the Model Penal Code, which pertains to sexual assault and related offenses. I will start out by telling you Tennessee does not currently use this. This resolution is intended to make sure we don't. And when I tell you about some of the things that are in it, I think you will agree with me. Firstly, Article 213 of the 2022 Model Penal Code would mandate the hiding of sex offender registries. Currently, that doesn't happen in any of our states. I see no reason why we should even think about it happening here, but we need to make sure we don't do that. Secondly, it adds, this penal code model adds a remarkably anti-victim change for a crime that's unmistakable. It allows a defense for someone who abused an underage child. Now, this is the one in particular that really gets me riled up. There is no defense for trafficking or abusing or otherwise taking advantage of a minor. And I don't care what this model penal code says. I don't want Tennessee to be involved with it at all, hence this resolution. There are some other things in there that I won't go into, but those two things alone are sufficient. And I ask for a positive vote. I stand ready to answer questions.
Any question for the sponsor? Seeing none, question been called. We're voting on SJR 0035. All those in favor say aye. Aye. All opposed, no. Ayes have it. Chairman goes to calendar.
Thank you, Mr. Chair and committee.
That brings up item number 4, House Bill 1431 by Chairman Hicks. There's a motion and a second. Oh, there's the chairman. All right, Chairman Hicks, you're recognized.
All right, thank you, Mr. Chairman, committee. House Bill 1431 increases the pay schedule for assistant district attorney generals and criminal investigators, as well as full-time assistant district public defenders and full-time district investigators.
You do have an amendment.
I do.
You have a motion and a second on amendment number 6650. Is that correct?
That's correct.
Okay. All those in favor of amendment 6650, say aye. Aye. All opposed, no. Okay, sir, the amendment's on the bill. Any questions for the sponsor? Leader Lambert.
Thank you, Mr. Chairman. Thank you for bringing this bill, Chairman. It is much, much needed. There's a lot of employees throughout the state of Tennessee that have gotten raises, that are attorneys that work very hard for the people of this state, but our assistant district attorneys, assistant public defenders, investigators, the pay has just lagged behind. And so it's really difficult to get folks to be able to handle these jobs. And I can say this as somebody who served as an assistant district attorney for 7 years. It's really tough. I mean, we're in session for several months here, and then quite frankly, we go back to our districts, we go back to our families, we go back and we're able to heal in a way and reconnect with our families. For an assistant district attorney, assistant public defender, and investigator, you just kind of wade out into the ocean of cases that you have to deal every day, and it just kind of hits you about chin, neck high every day, and you just have to get up the next morning and keep doing it to try to keep your community safe. These folks deserve to get better pay. So just thank you for carrying this, and members, I hope we support Chairman Hicks in this journey all the way through to the finish line to get it funded. So thank you for carrying the bill. Thank you.
Chairman Farmer.
And thank you, Mr. Chairman. I just want to reiterate a lot of what Leader Lambert said. You know, being in a courtroom practicing law, watching those public defenders and those district attorneys cart in, you know, milk boxes full of cases, you know, 60 in a box, stacked high. You know, a couple of them are trying to work those cases, work with those victims, work with those defendants, trying to give them the best representation possible. I think this is a great bill, long overdue. So just thank you so much for carrying this piece of legislation. It's, as Leader Lambert said, it's much needed. Thank you.
Representative Hardaway.
Thank you, Chairman. Good afternoon, sir. Do we have additional positions created with this bill?
Mr. Chairman.
Go ahead. Please.
Thank you, Mr. Chairman. No, this is simply, Representative Hardaway, for the salary increases on the salary scale.
Are there plans for increasing the number of positions?
I can't address that. My bill, again, just simply deals with the salary scale.
All right, thank you.
Thank you.
Mr. Chairman, thank you as well. Chairman Hicks, thank you for the bill as well. It's really unconscionable that we would have, professionals in our state doing the work and not being competitively compensated. Does this bill make it more competitive in the marketplace?
Mr. Chairman. And I'll give a little bit of context, Representative Towns, and I'll come forward and answer your question. Just some statistics here. The last 17 years, prosecutor and public defender salaries have not kept pace. So that's kind of answered the question and kind of set the tone. For example, and let me give you an example here, an attorney with 2 years experience, they could make over $105,000 at the Secretary of State's office, or about $100K with the Department of Safety. And that same individual, if they choose to be a prosecutor or a public defender, they would make $62,000. So that is certainly an issue. With the salary step program, it's still going to be tough to recruit and retain. There's no doubt about it, even if we pass this. However, we've got to start somewhere. I guess let me just say that. We've got to start somewhere, and I think this bill certainly is a huge step in the right direction.
Yes. Now, is it indexed to the inflation as well? Will they be able to automatically get those step raises that will help them to keep pace? Is that included in that bill?
No. No.
I would love to see that, where you wouldn't have to come back all the time and it would, kind of keep up with inflation. So this bill will allow them, a brand new prosecutor or defendant, start at what, 75, 80 or what?
If we're looking at, for the assistant district attorneys, about 63,853 would be what the assistant beginning entry level, again, that's entry level. Also for the criminal investigators, it would start out at 43,180. If you look at, and that's pretty close for the rest of them. That's pretty much what they would start out at in both cases.
With that bill, that's all they're starting out with?
Yeah, yes.
Man, you could pass out EBT cards to the people, man, with that kind of stuff. That's no money.
Yeah.
That's horrible.
I guess let me tell you where we're going from in two. If we're going from 53,388, again, for the assistant DAs, currently it's 53, this would take it up to 63, so that's a $10,000 increase. If you look at, for the criminal investigators, currently 33,852, the proposal is 43,000. So again, it's about a 10,000 increase, and that's pretty much for both.
Yeah, go ahead.
Mr. Chairman, let me tell you, I appreciate your effort, but we're playing with it, in my opinion. If we're going to give the folk a raise to make it competitive out of retained folk and secure folk, we should give them a substantial starting raise. That's just not enough, in my opinion. That's your bill. I'm with it, but it's not enough. I'm sorry, it's not. Not being a lawyer. As I said in one of the committee meetings, there's no way in the world you're going to pay off college debt with that kind of money. It's not. That's wrong. That's just wrong.
Representative Hardaway.
Thank you, Chairman. And this is for those positions that are paid strictly by the state. Would you explain the difference in those that are paid by the state versus those that have county funds associated with?
Right, and so for what I'm bringing forth, that would be for those prosecutors that, as you said, Representative, that are basically state employees. Now, the counties can go above and beyond what the state suggests or what they actually supply, I guess would be a better term. And they can provide their own salaries, and of course that is paid for out of the local fund. So it would be out of whatever source they choose. So that's how, I don't know if that answered your question. I hope it does, but that's basically the difference of the two.
Yeah, and you did, and I want that to perhaps resonate with our county officials, that they still have the opportunity to give our public defenders, public DAs, to give them more money than they're making now and bring it more in line with the private sector. Right. Thank you, sir. Thank you for the bill.
Okay, any other questions for the sponsor? All right, we are voting on House Bill 1431. All those in favor say aye. Aye. All opposed, no. Ayes have it. Sir, this moves to your home turf of finance.
Thank you, Mr. Chairman, committee.
That brings us to item number 5, House Bill 0458. You have a motion and a second there, Chairman Carr. You're recognized.
Thank you, Mr. Chairman. I do have another amendment I need to put on this, please. Amendment drafting code 6886.
6886, and you've already got a motion and a second. Do you want to present it first or tack it on first?
Well, let's tack it on, please.
All right. We're voting on Amendment 6886. All those in favor say aye. Aye. All opposed, no. Ayes have it. It's now on the bill. Please explain.
Thank you, Chairman and committee. This amendment does rewrite the bill. We took out the language about, we made it make sure that everybody is done the same on this. This is the BUI bill, boating under the influence. So this means Nashville had an exception that they only had to serve like some time for civic duty or clean up the parks or whatever like that. We took all that out thanks to Leader Lamberth. He helped me take that out. And so now everybody, if they get charged with BUI or DUI, it's the same charge all the way across the board. And with that, I stand for questions.
Leader Lambert.
Mr. Chairman.
I called your name.
Oh, I thought you had a question.
Oh, no, sir, I did not. But if you'd like me to ask a question, Mr. Chairman, I'd be happy to oblige.
No. We'll go to the next. Representative Hardaway.
Thank you, Mr. Chairman. Are there exceptions, or does this follow the DUI where there are exceptions for perhaps using the boat to get to work or things of that nature?
No, it's just sorry.
Go ahead.
Sorry, Mr. Chairman. It's just the straight DUI or BUI law there. If you get caught driving under the influence, or if you get caught boating under the influence, it's just like any offense would be.
And thank you for that. Mr. Chairman, perhaps we could go out of session and ask our legal to address that.
Okay, a question for legal. We'll go out of session.
Whether judicial discretion is allowed.
Michelle Fogarty, Legal Services. I don't believe the bill does anything to address any type of licensing for boating. It just addresses the penalties as far as making them align with the current DUI penalties.
Thank you. Thank you, sponsor.
All right. Any questions for legal? Yes, sir.
Thank you, Mr. Chairman. While we're out of session, I'd like to ask legal, does this revoke the driver's license, or was that the question that was just asked under conviction?
I don't believe it revokes a driver's license.
Thank you.
All right, any other questions for legal while we're out of session? All right, we're back in session. Any other question for the sponsor of the bill? Question been called on the bill. We're voting on House Bill 0458. All those in favor say aye. Aye. All opposed, no. Ayes have it. Sir, it moves on to finance.
Thank you, Chairman, committee.
That brings us to item number 6, which is House Bill 0555 by Chair Lady Littleton. You have a motion and a second. You are recognized.
Thank you, Mr. Chairman. It does have an amendment, 5357.
That's what I'm showing, 5357. And boy, we're on the move here. You got a motion and a second. You want to tack it on or you want to explain it?
Tack it on, please.
Tack it on. All right, we're voting on Amendment 5357. All those in favor say aye. Aye. All opposed, no. Ayes have it. Amendment's on the bill.
Thank you, Mr. Chairman. As amended, it rewrites the bill and was drafted by the Treasurer's Office. All changes to the statute are consistent with the federal requirements for the funding for the Criminal Injuries Compensation Fund. Section 1 provides some flexibility in the current statutory requirements that the claimant has cooperated with the police and the district attorney. Section 2, it adds to the current language to include victims of human trafficking to the eligible for pain and suffering compensation, along with the victims of rape and others currently listed in the statute. Section 3, current law provides a list of good faith exceptions to the requirement to the report to report the crime within 48 hours. The language is being amended to add victims of human trafficking to the current expectations list.
You've heard an explanation of the bill. Any questions for the sponsor? Representative Hardaway.
Thank you, Chairman. Good afternoon, Chair Lady. Is there a cap on the length of time in terms of the delay?
Go ahead.
The delayed reporting?
I don't think so. I don't see one in here.
All right, thank you, ma'am. Thank you, Chair.
Any other questions for the sponsor? Question's been called on the bill. We're voting on House Bill 555. All those in favor say aye. All opposed, no. Ayes have it. Chair Lady, this moves to calendar and rules. Brings us to item number 7, which is House Bill 398, also by Chair Lady Little. You got a motion and a second? Please proceed.
Thank you, Mr. Chairman. This requires a court to order a mental health evaluation treatment for juveniles who commit aggravated animal cruelty to a domesticated dog or cat, and authorizes a court to punish a parent or guardian in contempt of court for failure to comply with a required court order.
Okay, you've heard an explanation of the bill. Any question for the sponsor? Representative Hardaway.
Now you're talking.
Any other questions for the sponsor? All right, we're voting on House Bill 398. All those in favor say aye. Aye. All opposed, no. Ayes have it. Moves on to finance. If you don't mind, Chair Lady, on item 8, House Bill 1106, can I roll you about 2 spaces and give time for my assistant here to talk to you for just a second? Okay, we'll move over to House Bill 1400, item number 9 on the calendar. Is there a motion and a second? You have a motion and a second. This is showing an amendment 5367. Is that what you have?
That's what I have.
Okay, you want to tack it on or?
Tack it on, please.
All right, you've already got a motion and a second. Let's put it on here. All those in favor of 5367, say aye. Aye. All opposed, no. Your amendment's on the bill. Please explain.
Thank you, Mr. Chairman. This requires the sentence for a person convicted of rape, but no less than a sentence imposed for range 2 offender if the victim of the offense is at least 13 years old but less than 18 years old. Enhances the penalty for incest if the victim is a minor from a Class C felony to a Class B felony.
Is this 1400? Okay. Thank you. Any questions for the sponsor? Seeing none, we're voting on House Bill 1400. All those in favor say aye. Aye. All opposed, no. The ayes have it. That moves to calendar and rules.
Thank you, Mr. Chairman and committee.
That brings us to item number 10, which is House Bill 1109 by Representative Travis. Motion. You have a motion and a second. There you are.
I was waiting to marry you to move out of the way. Thank you, Mr. Chairman and committee.
You're recognized.
Yes, sir. House Bill 1109. It does one thing, and it just amends by adding the following: to harbor or hide the child within the outside this state, knowing that the child has been placed in the custody of the Department of Children's Services pursuant to a protective custody order or an emergency custody order entered by the court.
All right. I think we have some folks here that want to speak on this bill. John Gentry and Jessica and Chad Farley. If you're in the audience, please come and you can either, first one to speak, stand at the well or the podium, and the other two can sit in a chair right there, and you've got microphones right there if you prefer to stay in the chair. Please state your name and who you represent. If you represent somebody, and you have 3 minutes, and I think, Mr. Gentry, you wanted to make a couple of remarks that had nothing to do with your issue, just that you didn't want it counted against your time, so that's fine.
Yeah, just before the clock starts, I briefly want to express my profound respect for the chair. It's an honor to speak before you, sir. And the sponsor of the bill, Representative Travis, has my profound respect as well. I know his heart's in the right place. And other members of this committee, Representative Fritz, Representative Doggett, Representative Hardaway, I've personally witnessed them stand up for the people. And so I'm really honored to be here today.
Mr. Gentry, hold on one second. I've got to go out of session for the rest of your remarks. We're now out of session. Please continue.
Okay. And before I start my testimony, I just want you to know where I'm coming from. Judge Usman, Tennessee Court of Appeals judge, he recently stated in court order that from reading my work and hearing my oral argument, he said that John Gentry is deeply passionate and knowledgeable about the Tennessee Constitution. And that's where I'm coming from today, is about the Tennessee Constitution. So now to start the clock on my time, Representative Halsey, I don't have time in 3 minutes to explain my arguments here. So I encourage the members, please ask me to expand on the points that I'm about to make. This legislation is void for vagueness, and it smacks of due process violations. The void for vagueness doctrine is this: a man ought to know what a man ought not do. And please ask me to explain why this legislation or bill is void for vagueness. Prosecutorial evidence under this proposed legislation is inadmissible under the fruit of the poisonous tree doctrine. And that metaphor is this: if the evidential tree is tainted, so is its fruit. And the entire tree giving rise to prosecution under this legislation is tainted, and it is repugnant to Tennessee Constitution, Article 1, Section 6, 7, 8, and 9, and Article 11, Section 16. Ask me why this legislation, prosecution under it, is fruit of the poisonous tree. And this bill craves to be amended to add defense from prosecution. Please ask me how this bill should be amended. And government needs to get its own house in order before it starts prosecuting the family of children involved in DCS cases. Children in custody of DCS are sleeping on floors in offices and in hotel rooms. Children are sexually and physically abused while in state custody. And DCS is literally the principal pipeline for pornography, child trafficking, and prostitution. Let's fix and prove reform of DCS before we start prosecuting families that are harboring children from DCS. If DCS were subjected to the same level of scrutiny that parents are subjected to, every child in custody of the state would be removed, and that is a fact. It was agreed in our Declaration of Independence. He has erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out our substance. And more often than not, that's what DCS is: swarms of officers harassing our people. In 2020, the Physicians for Human Rights stated that forcibly removing children from parents causes catastrophic physical and psychological damage to the brains of children. And when DCS is taking children, more often than not, they are causing more harm than the alleged neglect. The fact that DCS cases are almost never criminally prosecuted is proof that these cases are primarily for what they call neglect or other reasons. And the courts and DCS can make these reasons to be whatever they want to be. And this bill desires to criminalize parents for protecting children from a broken and corrupt system. Representative Travis, I respect you. Please take this bill off the calendar. And for the members of committee, please ask me, what is void for vagueness? What is fruit of the poisonous tree? How would I amend this? Please ask me why this is in violation of the state constitution. Ask me to clarify my points. Thank you for your honor for your time, committee, and I would appreciate any questions from the members.
Thank you, Mr. Gentry. You have questions for Mr. Gentry? The exclusionary rule, yes, sir. Go ahead, Mr. Fritz.
Thank you, Mr. Chairman. I've got to ask you, the fruit of the poisonous tree, give me 2 minutes on that, please.
Okay, on fruit of the poisonous tree, Tennessee Constitution, Article 1, Section 6, the right of trial by jury shall forever remain inviolate. And parents having custody removed from DCS, 100% of these cases across the board, without exception, are removed without the benefit of trial by jury. Whenever there is a fundamental liberty interest at stake, like the God-given right to parent one's children, there should be a mandatory trial by jury. Article 1, Section 7, people shall be secure in their persons from unreasonable searches and seizures and general warrants without evidence of the fact and whose offenses are not particularly described and supported by evidence are dangerous to liberty and ought not be granted. And since reports to DCS can be anonymous, the offenses are almost always not particularly described, and they're never supported by evidence. And because DCS conducts interviews in our schools without notice to the parents, the people are not secure in their persons, and they're subject to illegal and unreasonable searches. And here's the most important one. Article 1, Section 8. No man shall be disseised of his freehold liberties or privileges, or in any manner destroyed or deprived of his life, liberty, or property by judgment of his peers or law of the land. And parents are deprived without judgment by their peers, and they are deprived without law of the land. You know, when you look at these reasons that children are removed by DCS, I mean, and I can go into this. We look at some of the reasons. I downloaded this from DCS website: environmental neglect, leaking gas from a stove, structural hazards such as caving in roof or holes in the walls, children that lack clothing, open windows, broken windows, like literally open windows. They can remove your children. That is not law of the land. That is policy from DCS. And so these removals are occurring in express violation of Article 1, Section 8. And Article 1, Section 9 about criminal prosecutions, that you have a right to face your accusations and to meet witnesses face to face. And because these accusations are anonymous, you can't meet them face to face. Because these are conducted in civil court and not criminal court, you're deprived the right to a trial by jury. The whole thing is fruit of the poisonous tree because the entire process is occurring in gross violation of our state constitution. And there's a reason that the framers put this in here. And that's why they said law of the land or judgment by the peers, because they knew the British ministry was making policy just like our DCS department is today.
Okay, Mr. Gentry, that's well past the 2 minute mark. Any other questions for Mr. Gentry? All right, thank you, sir. If you want to have a seat there. And
thank you, Chairman.
Jessica and Chad Farley, please introduce yourself. Make sure your microphone's on.
I'm sorry, sir. Mr. Chair, would you mind going out session for 60 seconds so that I can tell you where I'm coming from on this bill?
Well, no, we're already out of session. Go ahead and explain.
I just don't want it to go against my hard-earned work for 3 minutes that I did.
No.
Okay. Sir, I was in the military. I served. After that, I came home and spent 2 decades in emergency service in this state. I have 3 kids, one who is Special Forces in the Army, and I can't even show you his picture up here. Owner of a nonprofit and a campground, all to help others that I have met and the many that I hadn't met. When what I witnessed and what our family went through happened with bills like this, and I've never met this gentleman that just spoke, But you're gonna, why I shook my head, he was explaining what happened because of these types of things. And so I just asked that, as a parent, you listen to my 3 minutes. That's it. And I'm ready when they are.
Tell me what happened to your family, Mr. Farley.
Vote no. Stricter laws like this are given parts of the government who don't follow the very laws this House works hard to keep moving forward in today's world. Instead, we have government officials all over Tennessee who still continue to break the laws you're setting regularly in any situation that benefits them. How do I know? I was a part of it. More times than not, it's a show of power, specifically in DCS cases where on the ground, at the scene, the child's best interest or the lifetime of trauma that family and child is going to have to go on is not in the best interest. It's all about how bad the allegation was or how much you really just ticked off the caseworker. Some of you have heard parts of my case and how the very laws you passed intended for good were maliciously used out of context to tear our good family apart for two reasons: hate and jealousy. This is the reason I'm now going to start standing here. Bills like this, in this House, in front of this committee, every chance I get to tell you what the reality of these types of laws are doing when they're in the wrong hands all over Tennessee. Look at my case, how person after person of authority abused the work this very House had used all to harm only because of my private LGBTQ lifestyle, which was not accepted within a county. You don't believe me? It's on tape, along with police illegally stopping my wife, forcing her out of her car, and threatening to cuff her if she didn't come to court, where I was. No subpoena, no bench warrant, nothing other than they saw someone that could help them, force me to plead to something I didn't do. Don't believe me? It's on tape. 2 more hours on tape of our family being threatened by DAs and detectives trying to get something for a conviction. Why? A conviction was the only reason DCS could now hold my child. The types of laws like this are empowering those officials that don't abide by your hard work and laws already. Using those to violate my home, my children, my wife, and me. Morgan County Sheriff's Office and DCS thought it was over and I was just going to lay down until they started seeing their actions falling apart and becoming public. See, I knew my wife was in crisis, and even though I couldn't do anything about it, I knew after 14 years, she would get her sanity back, which she did a few days later after all these people were done using her. She was left alone, able to receive the medical treatment she needed in a mental health facility where she was when government officials first walked in. What this beautiful lady next to me needed was compassion and love. And that's what Tennessee is supposed to offer. And it's everything this lady deserved. While at her lowest moments, when involuntarily committed to a mental health facility, government officials are inside, not allowing her to be treated, in psychosis, diagnosed. They know she's ill. Would you want that for your daughter? Would you want that for your daughter-in-law, your granddaughter? All because the locals don't agree with their private life? I know that's not what this committee wants. That's not what you're for. And I know that's not what the people of Tennessee want. We've seen that outside. People are changing. And lastly, meanwhile, while nothing has been done to address the bold abuse of our laws and policies that were broken by DCS investigator Robin Witherspoon, Cassandra Wilmore, Sheriff Wayne Potter, DA Russell Johnson, and DA Jonathan Edwards, all sealed by Judge Mike Davis, who worked together to force an American veteran injured in the line of duty protecting my country to plead to something I didn't do, to
Mr. Farley.
cover the government agents wrongfully did when they maliciously abused the laws this House has already made and put in place.
Mr. Farley.
It's these laws they're using to come after our families, which are our pressure points.
Mr. Farley?
Sorry.
I'm sorry.
Well, I hope to answer a question.
Yes, sir. Are there questions for Mr. or Ms. Farley? at all, or Mrs. Farley, do you want to address the committee? Are there any questions for the Farleys? Yes, sir. Chairman Doggett.
Thank you, Mr. Chairman, and thank you, all of you, for being here today. I didn't know who all was going to be on the list, and so I'm going to direct my question at you because you're here. But last week in the subcommittee, it was brought up that this entire bill was built around anonymous reporting. I spent all weekend trying to do research on this and try to find that. Can anyone show me where that is in correlation with this bill?
If I'm understanding you, sir, you're asking how does anonymous reporting have to do with what I just said? Is that paraphrasing?
Get Gentry back up.
Because
Okay,
mine
Mr. Gentry.
started with an anonymous report, sir.
Right,
all
yes,
over
and I
TFAX.
know you. We've met. I worked on a bill about
I can't
anonymous
even see who-
reporting.
Sorry.
Yes, sir. I understand.
A lot of people don't know. Mine started with an anonymous report out of hate and jealousy. That's what today's world is. And it's unfortunate that our integrity is not like our grandparents. But this is the reality down here.
Mr. Gentry, can you address that question?
So how does this anonymous, well, technically they're confidential, not anonymous. So the accused never gets to meet the person, who's making the allegation against them. But where this breaks down at is this whole process, very often it's false and unsupported allegations. So now how does this play out to the bill? Well, if you've got a broken process and literally a very corrupt process going on where citizens are being literally harassed by attorneys for DCS, the case managers from DCS, they're forced to go through all these ridiculous hoops that takes them 2 years to go through while they're bowing to the will trying to get their kids back. This entire process is all so broken that when it gets to, that custody is removed and there's in DCS custody, when it gets to that point, you're going after a person who's been maliciously prosecuted by a person that they never get to know who made the allegation. So this is the problem why all of this, and as I mentioned, why the whole process is unconstitutional. And so, it's fruit of the poisonous tree. You've got a broken down process that results in a DCS custody order, and then the person, whether they know about the order or not, because it's void for vagueness, that the bill says knowing, and then I know in subcommittee they said, well, knowing is defined in the definition section. No, it's not. It says knowing means a person who acts knowingly. You can't define a word with the same word. It's stupid. It's tricky, deceptive attorney language in that definition that you don't know what it means. And then it says, and then it goes on in that definition saying that they know that the act will cause a result. And that's like, if you put a round in a chamber and you pull the trigger after pointing it at somebody's head, the result is they're probably going to be dead. You know that. But what's the result of harboring a child from custody from an agency that is absolutely broke and corrupt? And so I hope that answers your question, Representative Doggett. The way this anonymous plays in, they never get to meet their accuser. And the whole process plays out and custody is removed under an entirely unlawful process that's repugnant to our state constitution. And now you're going to prosecute them criminally with a Class E felony subject to 1 to 6 years in prison. And how is that going to help the kids? What if mom gets a custody order and she goes and drops the kid off with grandma? Maybe grandma knows. We don't know from the definition. And what, are they going to send grandma to jail for this? Stop this legislation. It is absolutely ridiculous that we're going to process when we can't even keep their own house in order in DCS. And I have literally seen, I have personally witnessed these things where they refuse to uphold rights, like a parent wanting to video record the interview. And the DCS worker and their supervisor is like, you can't record it. Why can't you record it? They want to conduct star chamber proceedings so that they can make false and unsupported allegations. This whole thing is about money. Each of these kids gets taken into custody. They're worth tens of thousands of dollars to the state government. It's in the budget. You know, they're getting hundreds of thousands, probably many millions of dollars are coming from the federal government in Title IV incentive money to reimburse the state for foster care. But they get more than dollar for dollar reimbursement. It's a profit center. And that's why this is happening, is because it's a profit center for this department and for the state. And it also results in litigation. And so parents got to hire attorneys. Attorneys are getting paid. Case managers are getting paid. Everybody's happy. And it is catastrophically and causing physical and psychological damage to the brains of children in the midtime. And now we're going to criminalize people that are trying to protect their kids from this process. So I hope that answered your question, Representative Doggett.
I believe there is a place, but we got to back up and punt, because what's going on, this is the process of what has happened to us. My wife has lost her hair, y'all. Like stress, all out of hate and ignorance, because you're with laws like this, you're arming these local people who don't, and there are a lot who do. I've worked with great people, but you're arming the ones that don't follow what you're telling them to do, and they're tearing good families apart.
All right, Chairman Doggett, do you have anything else?
Yes, sir. I thought 2 years ago we addressed the confidential reporting, that it was legislation that I carried, that we had a summer study over, and then we come back with some language that put you, if you were accused, I believe, I've seen a lot of bills and read a lot of bills over the last 3 months, but my memory may be slipping, but I thought there was a time when you had due process, that you were in court in front of a judge during this, in any hearing that was going to be an ex parte or anything of that nature that was going to take the children out of your home. I'm trying to link the confidential reporting to this bill, because it says you knowing. I would think that based off of that legislation from 2 years ago, that someone would know because they were there in the hearing and knew that their child was being taken, it was going into DCS custody. That's what I'm trying to figure out. I'm trying to bring all these, I know we're saying a lot of things, and there's a lot of emotion and passion, and I feel you. I'm right there with you. I'm just trying to corral all this down and kind of hone in and focus on this, and see if I can tie the direct correlation between confidential reporting and this bill, and how the two are connected or intertwined.
Well, you know, with the confidential or anonymous reporting that goes on, people can make up whatever they want, and you know, these reports, a doctor is recommending care a parent doesn't agree with, so he reports them to CPS. You know, dentists, teachers, school psychologists. You know, and I have personally witnessed this, that they just make up whatever allegations. And then they go in and they get an ex parte order. You talk about new legislation. They just came out with legislation. Typically, these cases are reviewed by a magistrate who is not a judge in juvenile court. And we're looking at legislation now that whenever you get a decision from a magistrate, you can motion for court review. You say, I don't accept this magistrate's order. I want a real judge to rule on it. And the existing process under that is that the court, the real judge, reviews the case de novo from the beginning as new. Now they're making it, and they're changing this, that the court review can occur that there's a presumption of correctness from the magistrate. We're going to assume that the magistrate, who's not a judge, is correct in this juvenile case. And again, this is all happening without benefit to trial by jury. You know, when you look at Miranda v. Arizona, everybody knows that case. You're denied due process if you're not advised of your right and you're not warned of the consequences. Here's what should happen. You have a right to a trial by jury. If you waive your right to a trial by jury, you may be subjected to a corrupt, biased judge who will not rule according to the facts and the law, but will rule according to his own pecuniary interests. Do you wish to waive your right to trial by jury? What sane person would? Confront adverse testimony face to face. The people don't even know what due process is and that their constitutional rights are being violated. I wouldn't get hung up on the anonymous part of this. The entire process is repugnant to our state constitution. And so if you've got custody transferred to DCS under an unconstitutional process, and then you want to criminally prosecute somebody with a Class E felony, 1 to 6 years. I don't know how we can do that in good conscience. And I know that the members here, many of you, I know, stand behind the Constitution and you stand behind the rights of the people. Let's fix our house first before we start trying to put more people in jail and subject them to more corrupt court proceedings.
Okay. Chairman, you.
I'm sorry, I don't know that I got the answer to my question. I don't know if legal services can.
I have my ADA rep here. Can she have 1 minute because my wife doesn't want to speak now?
She spoke in the sub, and so that rules out speaking here.
But I'm just trying to answer the question. He said he didn't get an answer. And I have one. I use my ADA rep back and forth to come up with what I need.
Oh, okay, I understand.
I have a traumatic brain injury. I apologize. Would that be okay?
That's fine with me. We need to wind this up, though.
You're allowed to speak for me. I can't get out what I told you I wanted.
Just one last comment on that, Representative Doggett, is, with these allegations as being, confidential or anonymous, and then it goes to an ex parte order, and the children are removed under these ex parte orders. And, these parents, very often, they haven't done anything, and it's certainly not law of the land. There's no law out there that says that you have to accept the medical advice of a medical professional. There's nothing in the statute that says it is neglect. In fact, neglect is not even defined in Tennessee Code Annotated. It is not defined. And what neglect is what CPS policy says neglect is. There's literally, and so that's in direct violation of Article 1, Section 8. And then you're going to criminally prosecute somebody for that. It just doesn't make sense. But because these are going to ex parte orders, and that it's based on confidential process, the whole thing just breaks down from there. How do you defend yourself? And then when you do get to hearing, you never get to confront the person who made the allegation against you. You don't even know what they are. Yep.
Could have cut them off in the parking lot.
Sorry,
Okay, any other questions? And we'll go back in session. All right, thank you, folks, for being here.
Thank you, Mr. Chair.
We're back in session.
Thank you, Mr. Chairman.
Leader Lambert.
Thank you, Mr. Chairman. I appreciate that spirited presentation, and I don't disagree with all of it. I, years, have joined Chairman Doggett and others dealing with anonymous complaints. I think there's too many of those, and I think we need better protections for that. The issue is this bill doesn't really deal with that. It talks about once an order has been entered by the court and you know about it, if you then take that child and against the order of the court, then you're in violation of this statute. It's just one paragraph. So I completely understand everything that's been said today. I appreciate the testimony, and I think there's much there that we should probably work on in another bill. But this deals with lawful court orders that have been entered, and then someone who is in violation of that, which is exactly what custodial interference is for everyone else. So if two members, if two individuals get a divorce and there's a custody agreement entered by the court, and then one individual violates that, it's custodial interference. So if a court enters an order and it deals with an emergency placement for children and someone violates that, there's no difference there. than in the other scenario. It's a valid court order, and if you know about it and violate it, again, this just puts it in line with the rest of the criminal statute. So I understand that there are folks that have given presentations upset about other issues, and I, for one, would like some bills that address some of that. I think there's some structural things that we should change, but this bill just doesn't deal with that. So to the sponsor, I appreciate you bringing the bill. I do support it. I'm just one vote, but I do feel like that our laws should include all circumstances where there's been a lawful court order. If this bill didn't include that, quite frankly, I wouldn't support it, but this does involve a lawful court order. Thank you.
Any other questions for the sponsor of the bill? Oh, I'm sorry, Chairman Russell, I didn't mean to pass you up there.
Thank you, Mr. Chairman. I just had a question for the sponsor. How would a prosecutor prosecute a defendant on a crime for this for knowing the child has been placed in DCS custody if the person hasn't been served with a protective custody order or emergency custody order?
Okay, it's a good question, Representative. These cases, the parents, will be known that it happens, that their child is going to be taken away from it. And to tell you how the courts will work against harboring or hiding a child, I do not know court that well to see how that would go out. I would have to go out to an attorney or something like that to answer that question on that one.
Go ahead, Leader.
Thank you, Chairman. I will say, since you've chosen to put this into the criminal statute, the one thing, and I hope this is the intent of the sponsor, this is going to have to be proven beyond a reasonable doubt. Yes. I mean, the burden is going to be on the state of Tennessee to prove beyond a reasonable doubt that anybody in violation of this knew. So, I mean, text messages, emails, phone calls. I mean, the state has the burden of this. So this is not civil that you're going into. It is a criminal case. And if they can't prove beyond a reasonable doubt, then this won't go into effect. I mean, so it does put it into the criminal realm, which does raise the burden, as it should. And so I did just want to bring that up. Again, it does make it in line with the rest of the criminal statutes, but I would akin it to an ex parte order of protection. If someone has knowledge of the fact that an ex parte order of protection has been filed against them and they have knowledge of that and violate it, there are some penalties that can arise, but you have to prove that knowledge. And so if they've not been notified through the court, if the state can't prove it, then there's no way somebody could be prosecuted with this. But it does raise the burden, and again, I think it should raise the burden to the highest level.
And thank you, Leader, for that. That answers my question perfectly. I just want to make sure that it's well described on how there's other ways for a defendant to know that this had been issued. Thank you.
Chairman Doggett.
Thank you. And I just, for clarity, I would like to know, how do you know? How do you know that your child has been placed in one of these protective orders or emergency protective orders? Because certainly I don't think it's your intent for a parent. Maybe a couple are divorced or they were never married, but they had children together, and one is in this town and one is in another town, and one of the parents is just not taking care of their kids, and DCS has been involved because of reports from school for various things, and they do home visits, and then they find out and they do this order, and mom or dad, whichever one, the other party is in the other town with the child, and they have no idea, and they take the kid to the mountains because it's their weekend. Just to, I would want to make sure that they are not prosecuted because they should have known at some point. Maybe the woman calls and she says, "Hey, by the way, DCS has got a protective order against Susie or Johnny or whoever," and like most folks would probably say, "Well, you're just trying to pull one over on me and get me back." So I'd like to know, how do you know? When do you know? Because I certainly would not want to have someone incriminated in an instance where maybe they were lied to by the other party. Because we do know that people do weaponize DCS, whether DCS is technically involved or not. People will threaten, to call DCS or whatever. So I don't even know if it made sense, but that's where I was Going around the world to get there.
Yes, sir.
Yes, sir. I think, Representative, I know what you're talking about because I heard you ask a question a while ago. The bill that's before you says hiding or harboring. It doesn't say how we do it at DCS. I've got the removal sheet from DCS, how that all works. I mean, we have all that. It's already in the law. So everything is in the law on how it works. We don't change anything like that. All we're doing is putting a clause in there that says hiding or harboring a child when they're being court-ordered by the DCS to remove that child. You know, we've had 2 Amber Alerts this year where a parent has taken that child, changed license plates, taken them out of state, and got them away because DCS was coming. In Spring City, Tennessee, there was a young man named Landon. We named a child place for him that didn't get taken into custody in time. He was made to drink dishwashing liquid, eat cigarettes, and the doctor said it looked like he'd been kicked by a mule. You know, we're trying to protect the children that needs to be protected. We're not trying to take children away from families. You know, we're not trying to do that. You know, if the DCS, if the DCS does have some issues, maybe that is another bill. But this is only hiding and harboring of a child that's been court-ordered be removed from the home.
Excuse me just a second. Chairman, she very well, the legal might have an answer for some of this, so we're going to go out of session. Legal.
Michelle Fogarty, Legal Services. Chairman Doggett, under the juvenile court rules and both the rules of civil procedure, if you are a party to a proceeding in a court, the rules require that you be served with a copy of any court order and any petition or motion that's filed. So if a parent is a party to a custody proceeding, the rules of the juvenile court rules and the rules of civil procedure both would require that the parent be served with a copy of that. This amendment expands the offense of custodial interference, which can be committed by a natural parent, an adoptive parent, a step-parent, a grandparent, a brother, a sister, an aunt, uncle, niece, or nephew of a child. So when it talks about knowing that the child has been placed in the custody of DCS and it's not a defense that the person harboring or hiding the child has not been served with an actual copy, that would, your grandparents, your brother, your sister, aunt, uncle, niece, and nephew are not parties to the custody proceeding, so the rules of court would not require that they be served with a copy of the order. But the prosecutor would have to prove beyond a reasonable doubt that they knew of the court order in order for them to be convicted of this offense. And as the leader mentioned, that could be by text messages. I mean, there just depends on the facts of each case how they could possibly prove that, but they would have to prove it beyond a reasonable doubt. And just to clarify, your bill from last year, or was it last year, about anonymous reporting is in 37-1-406E2, where it says if the report of harm was made to the department anonymously, then the juvenile court shall not order the parents or persons responsible for the care of the child or the person in charge of any place where the child may be to allow the department entrance for purposes of interview, examination, and investigation unless the department has presented evidence corroborating the anonymous report of harm.
Okay.
And one other point of clarification, under 37-1-107, a magistrate in the juvenile court shall be a member of the bar. So they are required to be attorneys in this state. And our juvenile courts are created by statute. They're not created in the Constitution. They're created by statute, and our statutes do not allow for jury trials in juvenile courts.
Thank you for that. So we'll go back to the very first thing that you said, that if there was a custody hearing, protective custody order or emergency custody order, that there would be a parent. Did I hear that right? There would be a parent present at the hearing?
I said they would have to be served with a copy of the order.
Okay, so they would have to have the order. So they necessarily would not been at the hearing itself. They would just be served with the order?
Yeah, that depends on who is seeking the ex parte order. I mean, every situation is different, but if, for instance, DCS was seeking an order against another parent, most likely DCS would be at the hearing, but the other parent would have to be served with a copy of the order. Just like when you have a domestic, an order of protection, the respondent is not present at the ex parte hearing, but the statute requires that they be served with a copy of any ex parte order. And there's a follow-up hearing.
Thank you. Mr. Chairman, we're out of session. Is DCS on the list for questions?
They are.
Would it be proper for them to?
Would you folks come up, please?
Are we not back in session? Do you have to gavel out again?
I thought we were out for the legal here.
Oh, okay, I guess we are.
Okay, please state your name and who you're with for the record.
Jim Lehman, Legislative Director for the Department of Children's Services.
Lisa O'Donnell, Legislative Liaison for the Department of Children's Services.
There you go. Okay, Chairman.
Thank you. Does DCS go before a judge without any parents knowing that they're subject of one of these hearings? Would DCS go to a judge and say, we want to take custody, emergency custody of this child without the parents being aware of?
Thank you, Chairman, for the question. I would like to start off by saying the department is defer on this legislation, and some similar questions came up during the subcommittee. I would say that so removal can happen in a bunch of different ways, right? And I think what the legislation is focusing on is that, despite the fact that the parent knew, right, most often, the parent would obviously know if their child is removed. Typically, a parent would be with the child, right, and they would have been removed. The legislation, I think, in the language that's at issue is saying, despite the fact that you may or may not have received formal notice, right, of a court order, which is, service of process is done in a very particular orderly process. And just because you haven't received that process, but you otherwise know of the order, that not having, not going under that service of process isn't a defense, right? But to your question, there can be safety situations, right, where children would be removed, and then the court hearing would happen later, right? But remember, too, that for everything, that was said previously, that it's not just up to the department to remove children. These are all things that are ultimately decided by the court, right? Like, we can't make just a unilateral decision to remove children and that be what continues forever. If we make that decision on an emergency basis, then that goes before a court, I believe within 72 hours. I'd have to check for sure. But so these are all things that are played out in the court system, if that answers your question at all.
So the department could go to the court without me or my wife knowing that they were there asking for this order without our knowledge, and a judge could sign off and say yes to the department, but me or my spouse were not there to be heard. Is that correct?
I think I'm going to defer to Hayes here.
Yeah. Good afternoon.
Oh.
In regards to removing a child into custody without a court order, that can happen in situations of emergencies, correct? And there's two different ways that can happen. So regardless of which one it is, it can either happen, before a judge is notified. The second option could be a judge could be on a phone, right? A different form of communication versus in person in a court. With that, an order would be given within 48 hours and a hearing would be heard within 72 hours with all parties being notified and hopefully present for that court.
one situation I'm thinking of, Chairman, think about abandoned children. I mean, children can be simply abandoned and not be with mom and dad. And it may be that the state is the only one that is there to care for them until we're able to, find mom and dad and serve them with orders. And, if that's the case, that they were abandoned in such a situation that we feel that they should remain in custody. I mean, it's very fact determinate, very fact dependent. But I mean, just off the top of my head, there's certainly situations where children are abandoned and mom and dad aren't even there to know that it's the state that decided to, care for them. So.
What about the ones that are perfect and nothing was wrong and it was used out of hate? There's two sides to this.
Mr. Farley, I'm sorry.
Go ahead, sir.
I'm sorry. There's no discourse in between benches here, all right?
I apologize.
All right, thank you. Any other questions there, Chairman?
No, sir, thank you.
Chairman Russell.
Thank you, Mr. Chairman. And how often does this happen where you would need this written into law?
Do you mean the offense of custodial interference?
This new part that sponsors want to add to the statute, how often does this happen where you feel that you need this?
Well, again, we are defer on the legislation. I wouldn't say that it's something that we've proactively, stated that we need or anything like that. But I'm not sure. I'd have to ask, I don't know how frequently we've dealt with folks intentionally disobeying court orders and harboring children when they're aware that that the child is in DCS custody. But I could try and find out if there's any way we keep that.
Without mentioning any names, could you recall any in the last 5 years where you would need this?
Yes.
Thank you.
All right. We're through with the legal and out of session. We're back in session. Thank you very much. Any other question for the sponsor? Okay, I just have one.
Yes, sir.
I'm assuming on the face of the bill, even though the wording of it has really lit people up. But it seems to me that the intent of the bill is if a husband and wife, for example, have an order from the court through DCS that they're going to remove their child for a period of time based on allegations of whatever, and Granny hears about it and picks up the kid and takes it to Granny's house, and nobody knows where the kid is, and the parents don't tell, you're trying to expand custodial interference over to this kind of scenario for that. Am I correct in that?
Chairman, I'm not quite sure how that would play out. If my daughter was to overdose on drugs or something like that, and that child was in the back seat, and I would open my arms to bring that child, but I would probably do it through the courts and through the DCS.
Okay. Just trying to look at the wording of the bill, and it seemed to me like that's what it applied to. My question is, it's kind of hard to hit Granny up with a Class E felony.
It would be tough.
All right. Any other questions? Yes, Representative Davis.
Thank you, Chairman, and thank you to the sponsor. And so if there is a family member, if there is a situation, just like you said, that there, let's say it's a drugs or any other, terrible situation like that, in the majority of cases, do not DCS and also the courts try to place that child with a family member first, that they always try to keep that family whole first. Is that not fair? And yes, I guess, I can understand where there might be some outliers and understand some of the concerns, but it sounds like this is more of a serious intentional act that you're trying to target. Is that a fair?
Yes, Representative, that is correct. Thank you.
Chairman Duncan.
Well, I don't know if Representative Davis was through with her comments or not, but okay, I'm sorry. Thank you, Mr. Chairman, and I apologize. It was not my intent to take over with a lot of questions. Statements were made when I went back and watched the video from last week in the subcommittee. There's just a whole lot of things that are going on at that time, and so I had some time to reflect on some of the comments that were made. And I know that a lot of times, and like Representative brought up, that trying to place in the family, when I first saw this language, this proposed language, that was what I was thinking, was that they've already been taken custody and given to grandma or aunt or whoever the case may be temporarily, and then mom or dad or whoever the guardian is comes and gets them and takes them away knowing that. That's how I first read into it. But then some comments that were made in the committee got the wheels turning up here, and I started digging, and I was trying to bring those two together. I still don't know that I've connected all the dots in my head. I just want to apologize for taking time up in the committee, but I'm just trying to figure this out, because I know that we want to make sure that we're protecting children and not putting them in harm's way and putting them with folks that would continue to do them harm. But I also think about parents and guardians who sometimes they feel and that this type of thing could be weaponized against them, and I don't want to do that. And so it's a tightrope walk and that we're on. And so I just want to apologize for taking up a lot of time with the committee, but that's just something that I'm still trying to wrap my head around. So, thank you.
All right. Representative Fritz.
Thank you, Mr. Chairman. Great discussion. When I read this bill, I read something that's very specifically addressing a scenario. My heart goes the same place as Representative Doggett does too, and we've brought up lots of things I think we need to talk about. But when I read the bill, what we're talking about, it's to protect those kids that perhaps a parent who didn't have custody went and took. And so as difficult as it is, I think that's worth, at least that's what I'm hearing to the sponsor. Am I hearing this correctly?
Okay, any other questions? Oh, you were asking a question. I'm sorry. I'm so sorry. I thought you were making a comment. All right, go ahead.
I answered him, yes.
Okay, now it's my turn. All right, are there any other questions? There are no more questions being called on the bill. House Bill 1109. All those in favor say aye. Aye. All opposed, no. No. The ayes have it. If you want to be recorded as a no, see the clerk. Thank you.
Thanks, sir.
Goes to calendar and rules. Brings us back to item number 8, House Bill 1106, and that is rolled for 1 week. Puts us back to item number 11, House Bill 0403 by Leader Lambert. Leader Lambert, you're recognized.
Thank you, Mr. Chairman.
Is there a motion? All right, go ahead.
Thank you, Mr. Chairman, and there is an amendment that makes the bill should be coded 6269.
That is what I have. You want to put it on?
Yes, sir, Mr. Chairman, if you'd be willing.
We're voting on Amendment 6269. All those in favor say aye.
Aye.
All opposed, no. Ayes have it. Amendments on the bill. Go ahead.
Thank you, Mr. Chairman and members of the committee. This is the same bill that we carried all the way through criminal justice and got almost to the floor last year dealing with hemp-derived cannabinoids, and it just puts guardrails on that and much-needed regulation. Right now, a 7-year-old could walk into any gas station and buy as much Delta-8 as they would like, and it's just a substance that needs to be heavily regulated. I will admit publicly that if I had my druthers, I would make it illegal again, but we tried that before. It didn't work out so well. And so the best we can do is put some heavy regulations on this to make sure that children don't get these substances, and adults that do wish to utilize them know exactly what they are getting with testing and labeling, and that everybody knows. And so I believe, anyways, that will make it significantly safer.
Okay, you've heard the explanation of the bill. Any questions? Question being called on the bill. House Bill 0403. All those in favor say aye.
Aye.
All opposed, no. Ayes have it. Moves on to Governor's office.
Thank you, Mr. Chairman, members of the committee.
Moves us to item number 12, House Bill 1126 by Leader Sherrill.
Thank you.
You got a motion and a second? You're recognized, sir.
Thank you, Chairman and members. House Bill 1126, it requires a person convicted of allowing their dog to run at large that results in bodily injury, serious bodily injury, or death of another, or damage to the property of another to pay restitution for all damages that arise out of the related or such offenses. Currently, judges can only fine as an individual and require restitution for damages. So we're just pretty much asking for restitution.
All right. You've heard an explanation of the bill. Any questions for the sponsor? Well, seeing none, we're going to vote on House Bill 1126. All those in favor say aye. Aye. All opposed, no. Ayes have it. Leader Sherrill, it moves on to calendar and rules. That brings us to item number 13, House Bill 908 by Vice Chair Gillespie. You have a motion and a second. You're recognized, sir.
Thank you, Mr. Chair. This is, I guess, part of my comprehensive strategy to address bad driving in the state of Tennessee. What it simply does is if you commit the offense of drag racing, which is a criminal offense, we will take your vehicle from you and use those funds and give them to the Traumatic Brain Injury Trust. And I believe we need to back up real quick. I have an amendment.
You do have an amendment. 6929, is that what you have?
Yes, sir.
All right, we're voting on amendment. You got a motion? And a second? We're voting on 6929. All those in favor say aye. Aye. All opposed, no. Ayes have it. The amendment's on the bill. Okay.
All right, sorry about that. Let me back up, or not back up. What we are doing here is allowing for the confiscation of vehicles to help tackle this problem that is just completely out of control in my neighborhood, my city that I live in, and across the state and country. Drag racing is an extremely dangerous activity. It is even more dangerous when you're doing it on a public street with other drivers that are unaware that they're participants in a race. People have been terrified for quite some time now, and I believe this will significantly help put a dent in this dangerous activity before more people die. And with that, Mr. Chairman, I renew my motion.
Okay, you've heard the explanation. Any questions for the sponsor? Nope. Well, can you withdraw for just 1 second? I only have one problem with the bill. And I understand you got a problem with what you're trying to deal with. It just troubles me that if somebody has a $30,000 car that the state's going to confiscate, but the charge for drag racing is a Class A misdemeanor, that's a pretty hefty fine for that Class A misdemeanor offense. I just have real problems with it. But we're ready. You can now make a question on the bill.
Matt, may I ask a question?
Yes, indeed.
Just real quick. Thank you, Mr. Chair. As I understand it, I don't think the issue would be that a person would be charged with this crime and their vehicle then would be taken without due process, right? So it's going to be confiscated and then by the state, and then they would have the opportunity to defend themselves in court, right, for the crime and also then for their vehicle. I guess in two separate proceedings as it is now. Is that how it would play out?
Is that how it play out?
Thank you, Mr. Chair. Yes, so my understanding is in order for this to take place, you have to be committing a crime. So it's not a, you can't have one without the other, if that answers your question. And then there's due process for when you're convicted, or if you're convicted, I should say, that then you can, there's already procedures in place that I'm not changing at all to make that case to the Department of Safety to allow.
Okay, let me ask you this way. So we're just making the crime of a misdemeanor drag racing, we're making that crime and opening it up to where your vehicle is going to be, it's going to be a seizable offense for your vehicle. Is that correct?
Go ahead. Yes, that is correct. And also, I will remind everyone that 2 years ago the Tennessee passed a law that I proposed that increased that penalty from a B misdemeanor to an A misdemeanor. And at that same time, I wanted to make it a felony. So that is, I'm at the will of the body here to fix this problem however we see fit. I'm just looking for a solution. I don't really, I'm at the will of the committee here. If we want to come back and address this and make drag racing a felony, I'm fine with that. Or if we want to go ahead and proceed with this, I'm also fine with that.
Thank you, Chairman. That, by the way, Chairman Farmer, you're aware of the Eighth Amendment. They ruled under that excessive fines for as being cruel and unusual when the fines far outweigh the offense. Yes, Chairman Doggett.
Thank you, Mr. Chairman. When we go back and visit 5510-502, where this is going to be adding in a new section, there is, in Section C, motor vehicle used to commit the offense of drag racing or to flee after the commission of the offense of drag racing is, upon conviction for the offense, subject to seizure. So there is, if there is a conviction, but your amendment would say that there was not a conviction necessary for the seizure of the vehicle. Is that a correct statement?
Go ahead.
Thank you. Yes, that is. I mean, if we really want to get to the root of the issue here, I can really go into a lot of detail here that would love to clarify some things. But again, it's up to you all.
Chairman?
Well, thank you. I appreciate what you're considering here with this bill. And again, I apologize I didn't catch this any sooner, but I think there's already, just in my personal opinion, my feeble mind here, there is opportunities to maybe accomplish what you're looking at doing, particularly with this amendment by, there's already a mechanism for the seizure and forfeiture in this section of code we're seeking to amend, that it may just be as simple as maybe coming back and putting in the proceeds from the sale or whatever of that vehicle used in that offense to go to the brain, the organization or group that we had listed. But that's just my thought. I share the same thought that Chairman Halsey does, that it is a little excessive if there is not a conviction. However, that there is already listed in this section of code a mechanism, but it's based upon the conviction in this case.
Yes, sir.
Thank you, Mr. Chairman. I completely understand what you're saying, Chairman Doggett. I'm going to make a motion here in a moment after you just hear me out. Because the number changes every day, I believe last year there were roughly around 400 arrests in Memphis city limits alone for drag racing. None of those were prosecuted for drag racing. So the issue itself is the state's definition of what drag racing is now either needs to change, or we need to take proactive action to punish someone that is committing a crime so that our streets are safe, essentially. Again, I say that just because this is something that is day-to-day constituent concerns of mine, whether you're going to the grocery store or driving to Nashville or anywhere in between. There's not a single day that does not go by that I'm not hearing something about being cut off by organized street racing. The situation is so dire that weekend before last on the interstate, there was a street race that was organized, and a fire engine was stopped in its tracks that was responding to an elderly in distress. Last summer, there was a situation where part of 240 was blocked at the Walnut Grove exit to Baptist East Hospital. There was an ambulance that was stopped in its tracks. If the ambulance had a patient on board, that patient would have died. So I'm more than willing to go back and relook at how we define drag racing as a whole. But I think this is an easier solution that does hold up to muster. So again, I'm completely at the will of the committee.
Representative Fritz?
Thank you, Mr. Chairman. Thank you for the bill. And I understand you've got a problem with this in your county, but this would apply to everybody in the state, correct?
Yes, only under what's currently defined as drag racing.
And so I struggle a little bit with pulling the $30,000 car example for one case of that in Roane County, simply because we've had 400 cases of it in Memphis, and the folks there won't prosecute it.
Go ahead.
Thank you. I'm probably not making my case here, but I'm just trying to be truthful with y'all. Honest politician, I guess. What's going on in Memphis, 30,000 cars is not really what we're talking about. We're talking about $100,000+ cars. These are people that know exactly what they're doing. They see what our laws are now and are just slapping us in the face. The $2,500 fine that they get right now, they've got a $100,000 car. They're not worried about the $2,500 fine. So that's just, again, I appreciate your concerns, but we have to start somewhere. And if it means protecting the entire state by doing something like that, I'm all for it.
All right, any other questions for the sponsor? Oh, Chairman Farmer, I'm sorry.
I've got a motion.
Oh, you got a motion, all right. Chairman Russell.
Thank you, Mr. Chairman. I just want to say I like the bill. I just think that they should be convicted of the crime before the seizure happens, or actually they can seize it, then keep it if they're convicted. That's sort of what I was hoping to get to. I wrote many tickets for drag racing, and some of them got convicted, some didn't. And we got the Dragon through my area up there, and when they'd come off the Dragon, they go down 72 East there, and they go over there and drag race on those straightaways. And I've written a bunch of tickets for it, but I would like to see this go through if they're convicted. So thank you.
I lost every time I raced up here. I'll just say.
Still looking for you.
Okay, Chairman.
No, thank you, Mr. Chair, and appreciate the sponsor bringing this bill, well-intended. And I know there's nothing you can do about your prosecutor in Memphis, whether or not they're prosecuting what they need to prosecute. But with that said, two prosecutors. I think we can work on this, help Representative Gillespie get to where he needs to be. Mr. Chair, members, I'd make a motion we roll this to the first calendar of 2024, keep it in this committee in the criminal full.
All right, been a motion and a second. All those in favor say aye. Aye. All opposed, no. The ayes have it. Roll to the first calendar 2024. All right, that brings us to item number 14, House Bill 0830, also by Vice Chair Gillespie. Motion and a second? Second. You're recognized.
Thank you, Mr. Chair, and I have a amendment here.
Yes, you do. 6780.
That is what I have.
Okay, a motion, and is there a second on the amendment? I heard a second. All right, we're voting on the amendment. Boys, the day goes long, you people are getting hungry, but you're not speaking up. All right. We're voting on attaching amendment 6780 to the bill. All those in favor say aye.
Aye.
All opposed, no. The ayes have it. The amendment's on the bill. Go ahead.
Thank you, Mr. Chair. What this does is it attempts to address our kind of revolving door that we're constantly hearing about in our criminal justice system to add some transparency to the bail process in the state. What this bill would do, essentially, is if you commit or are arrested for a Class A or B felony or aggravated assault against a first responder, domestic assault, then you would be required, bail would be required to be set by either a general sessions judge, criminal court judge, or a circuit court judge having jurisdiction. And what this would also do is, while out on bail for one of those offenses, if you are rearrested, then the judge or magistrate in the case will just simply set bail again instead of being allowed to be out on your own recognizance from the previous bail that was set, or bond that was set. With that, I welcome any questions.
All right, any question for the sponsor? Question been called on the bill. We're voting on House Bill 830. All those in favor say aye. Aye. All opposed, no. The ayes have it. Moves on to calendar and rules. We're up to item 15, House Bill 689 by Representative Hardaway. Roll that. Motion been made to roll next calendar. Any objection? All right, this is rolled to next calendar, next week. That brings us up to item 16, which is my bill. So, Vice Chair Gillespie.
All right, Mr. Chairman, you are up, and I see that you have an amendment. Would you like to? I'm sorry? May I have a motion and a second, please? Thank you. All right, Chair. I see that you have an amendment here, 5925.
I've got to get the right bill. This is Davis's bill, right? I'm so sorry.
You are absolutely fine. It's been a long day.
All right. This bill deals with the fact that several years ago when...
Sorry, do we want to adopt the amendment?
Yes,
or-
we do. It's 5925.
All right. All those in favor of adopting Amendment 5925, say aye. Aye. All those opposed? The ayes have it. All right, sir, please proceed.
Several years ago when AIDS came along, we passed legislation in the House here, and it made it a felony to knowingly or unknowingly spread the AIDS virus. And along with that was an order to go on the sexual offender list. And this bill simply doesn't do anything with the criminal side of it, but what it does say is that starting in July 1st, somebody who has consensual relationship with somebody and they get AIDS, whether they're charged criminally or not, they don't go on the sexual registry list. And if you were on the list prior to July 1st of this year, you can appeal and go through a process with TBI to get your name removed from it. And that's what the bill does.
All right. Does anyone have any questions? Question has been called. All those in favor of sending House Bill 832 to Finance, say aye. 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 All those against? No. The ayes have it. All right, sir. Off to Finance.
Thank you very much, Vice Chair. And I am sorry that I got so tangled up with my bill I couldn't even see the right one. Okay, we have survived and made it through the whole calendar. We now have one bill on the enhanced calendar, and that is House Bill 248 by Representative McCalman. There's a motion and a second. Did you see the exuberance in that right there?
Yes, Mr. Chairman, I think they're going, I'm going to go home. Let's get this guy out of
I think
here.
you're right.
Thank you, Mr. Chairman. I do have a amendment.
Do you have Amendment 6875?
Yes, sir, I do indeed.
That's what I show. There's a motion, a second on the amendment. All those in favor say aye. All opposed, no. Your amendment's on the bill, sir. Please explain.
Thank you, Mr. Chairman. Members, I will be brief because we all want to go home. Basically, what this bill does is it says if you are convicted of domestic assault, you will serve a minimum of 30 days incarceration. If in this process you strangle somebody unconscious, the DA will have the ability to pursue attempted homicide against you, and if they pursue attempted homicide, that will be a Class B felony. And with that, I stand ready for questions.
Okay. Any questions on the bill? Chairman Doggett.
Thank you, Mr. Chairman. Excellent bill.
Thank you, sir.
Question on the bill.
Question been called on the bill. We're voting on House Bill 248. All those in favor say aye. All opposed, no. The ayes have it, sir. It moves on to finance.
Thank you, Chairman and Committee.
Thank you, and I appreciate your waiting. Is there any other business for the committee? Food business. All right, is there a motion to adjourn? All right, we are adjourned.